Hello everyone, this is Mike Rementus, MADMAN Reviews, resident gun nut. In this video, I'll provide an update on what's currently happening in Rhodi v. Bonta. For those who have no idea what it's all about, I'll provide background to get you up to speed. Just as a quick disclaimer, all the info I'll provide in this video does not and is not intended to constitute legal advice. Instead, all information, content, and my opinions on the matter are for general informational and entertainment purposes only. If you, a friend, or a loved one is a responsible gun owner and a law-abiding citizen living in California, then you or they are probably aware of the state's pointless and unconstitutional ammunition purchase restrictions. If you think I'm wrong that those laws do help with gun violence prevention and they do not infringe on your Second Amendment rights in any way, feel free to comment down below. California Proposition 63, the Safety for All Act of 2016, and Senate Bill 1235 of 2016 were enacted to regulate the sale or transfer of ammunition in California and went into effect on July 1st of 2019. These laws require California citizens to undergo a so-called instant background check before they can purchase ammunition. Depending on certain issues surrounding the people who implement these laws and/or their processes, you, your friend, or your loved one will either have to wait a few minutes or a few days before you or they can purchase ammo. Worse, there's a possibility that you won't be able to purchase ammo at all, even if you are a law-abiding citizen. What you need ammo for depends on your life situation, but in general, without ammo, a gun is just an expensive paperweight. The Second Amendment states that the right of the people to keep and bear arms shall not be infringed. The term arms is a collective term, which includes both the firearm and the ammunition, as anyone with half a brain knows that neither one can be used without the other. California's system of implementing these unconstitutional laws is flawed. If you go to calwaterfowl.org's page where they posted a long write-up to help people navigate this flawed system, they described how 1 in every 6 people will never pass the background check. The instant background check is based on the California Department of Justice having a record of the ammo buyer having passed a background check to buy a gun. For 5 out of 6 Californians, the process goes smoothly. They show their California driver's license or military ID, pay $1 for a background check, wait a few minutes, pay for their ammo, then walk out of the store with their ammo. 1 in 6, however, can't pass the background check. And the reason for the overwhelming majority of them is rooted in records. Of the 102,147 people these laws have stopped from buying ammunition as of this writing, 758 were actually prohibited persons. The rest were just rejected by a system that works poorly. The only place background checks aren't required by law is shooting ranges, but ranges can skip the background check only if the ammo you purchase is used in its entirety at the range that day. You can't take any home. Some ranges may choose to require background checks anyway to avoid risk. Want to get around this law by stocking up on ammo in another state? Well, you can buy ammunition out of state, but to bring it into California, you first have to ship it to a licensed California ammunition vendor so they can perform a background check and hand your ammo back to you. The law does not limit the fee the vendor can charge for this service. So here's a summary of Rhodi v. Bonta, 9th Circuit Court, case number 20-55437. On April 26, 2018, a group of concerned citizens and corporations that I'll refer to as plaintiffs filed a lawsuit in the Southern District Court of California against the Attorney General of California to seek declaratory and injunctive relief, arguing that these new ammunition purchase restrictions are unconstitutional because A. They violate the Second and 14th Amendments to the United States Constitution. B. They discriminate against interstate commerce in violation of the Dormant Commerce Clause in Article 1, Section 8 of the United States Constitution. C. California Penal Code Section 30314 unjustifiably denies plaintiffs as California residents of equal treatment to out-of-state residents in their exercise of the fundamental right to acquire ammunition. And D. California Penal Code Section 30314 conflicts with and is thus preempted by the 18 U.S.C. Section 926A. The case dragged on for 2 years until April 23, 2020, when Judge Benitez granted the plaintiff's motion for preliminary injunction ordering the Attorney General to stop enforcing the laws in question while the case is pending. But the very next day, April 24th, the Ninth Circuit Court of Appeals granted the Attorney General's emergency motion to stay, which allows the state of California, to this day, to continue enforcing its unconstitutional ammo purchase restrictions. 6 days later, April 30th, 2020, the plaintiffs filed their opposition to appellant's emergency motion to stay preliminary injunction order pending appeal. On September 23, 2020, the Ninth Circuit Court ordered both parties to file their respective supplemental brief regarding historical evidence that either proves or disproves Judge Benitez's finding that an ammunition background check has no historical pedigree. In response, both parties filed their supplemental briefs on October 14, 2020. The plaintiffs argued, quote, 1. There is no historical evidence that either ammunition background checks in particular or ammunition laws in general fall outside the scope of the Second Amendment. 2. Ammunition background checks do not fall into any of the categories that Heller described as presumptively lawful because a. Ammunition background checks are not prohibitions on the possession of firearms by felons and the mentally ill. b. Ammunition background checks are not presumptively lawful conditions and qualifications on the sale of arms, and c. Firearms background checks are neither categorically outside the scope of the Second Amendment nor analogous to the state's novel ammunition regulation regime. For those reasons, plaintiffs conclude that the Ninth Circuit Court should reject the notion that California's novel ammunition regime is outside the historical scope of the Second Amendment and affirm that Judge Benitez's order granting motion for injunction to stop these ammunition purchase restrictions from being enforced. The Attorney General of California made the following arguments, which in my opinion are simply dumb. 1. Step 1 of the Heller analysis looks to history and practice. A. There were laws with origins in the 20th century that provide persuasive historical evidence. B. Some of those laws may be upheld as long-standing regulations if they are reasonably analogous to laws in earlier historical periods. 2. Persuasive historical evidence shows that California's ammunition laws are part of a long-standing regulatory practice because a. States began consistently regulating the sales of firearms and ammunition in the early 20th century. B. Background checks are long-standing in America. C. Laws necessitating in-person purchasing are long-standing. D. Record-keeping laws are long-standing. Laws requiring identification are long-standing. The Attorney General of California further concluded that the Ninth Circuit Court should reverse the District Court's April 23, 2020 order entering a preliminary injunction and order judgment entered in favor of the Attorney General on the Second Amendment and Dormant Commerce Clause claims. On November 16, 2020, the Ninth Circuit Court ordered both parties to file their supplemental briefs regarding the constitutionality of the basic check. A month after, the Attorney General filed his supplemental brief in response explaining the process and implementation of an individual's eligibility to purchase ammo, and again making pathetic arguments. Quote, the basic check is a constitutionally permissible regulation of ammunition because A. It is a presumptively lawful regulatory measure. B. It advances California's interest in public safety and is appropriately tailored to that purpose. C. The plaintiff's challenges to the basic check failed. The Attorney General again had the nerve to conclude that the Ninth Circuit Court should reverse the District Court's April 23, 2020 order entering a preliminary injunction and order judgment entered in favor of the Attorney General on the Second Amendment and Dormant Commerce Clause claims. On January 15, 2021, the plaintiffs filed their supplemental brief in response to the Ninth Circuit Court's order from November 16th of the previous year. They made three strong arguments. 1. The basic check creates significant impediments to the exercise of Second Amendment rights. 2. The basic check is not sufficiently tailored to further the state's proffered ends. And 3. The state's contrary arguments are unavailing. The plaintiffs then concluded that for those three reasons, the basic check is not constitutional in its own right. On March 19, 2021, the Ninth Circuit Court ordered staying the case pending Duncan v. Bonta, case number 19-55376. Over a year later, June 24th of this year, the Ninth Circuit Court released another order order directing both parties to file supplemental brief in light of the Supreme Court's decision in New York State Rifle and Pistol Association, Inc. v. Bruen. On August 8th of this year, the Attorney General filed their supplemental brief. In it, they argued that 1. Bruen altered the legal standard for analyzing Second Amendment claims. 2. The ammunition laws do not regulate conduct protected by the plain text of the Second Amendment. And 3. This court may remand this case for further proceedings consistent with Bruen. The Attorney General concluded that the Ninth Circuit Court should, quote, reverse the District Court's order entering a preliminary injunction and order the District Court to enter judgment in the Attorney General's favor. In the alternative, it should vacate the District Court's order granting a preliminary injunction with respect to the Second Amendment claim, direct that judgment be entered in the Attorney General's favor on the Dormant Commerce Clause claim, and remand this case for further proceedings. Can you believe the nerve of this guy? 3 weeks ago, on September 22nd, the plaintiffs filed their supplemental brief in light of Bruen. They argued that 1. Bruen discarded this court's two-step framework in favor of an analysis focused solely on text and historical tradition. 2. Historical tradition confirms that the district court did not abuse its discretion by enjoining California's one-of-a-kind ammunition regime because A. California's novel ammunition regime regulates conduct squarely within the ambit of the Second Amendment, and B. The state has identified no historical tradition lending any support to conditioning the purchase of ammunition on perpetual background checks. Following their arguments, the plaintiffs again made the conclusion that the Ninth District Court should affirm Judge Roger T. Benitez's ruling from April 23, 2020. The GOA and other amici curiae on the side of the plaintiffs have filed their brief, arguing why the Ninth Circuit should not remand this case to the District Court and simply rule on it in light of the Supreme Court's new Bruen standard. So, let's talk about the possible outcomes for this case. If the Ninth Circuit Court panel reviewing this case includes known conservative judges like Judge Bonta and or Judge Van Dyke, they'll very likely affirm Judge Benitez's 2020 ruling. Otherwise, this case will probably be remanded to Judge Benitez. If the case is remanded, Judge Benitez will only reaffirm his previous ruling following the Bruen standard, which is practically just a simplified version of the two-step standard used in Heller. It may take several months because the Attorney General of California is a master of delaying tactics, but he can't stop Judge Benitez from granting the plaintiffs declaratory and injunctive relief. In the unlikely event that the Attorney General is able to get the Ninth Circuit Court to rule in his favor, the plaintiffs will file a cert petition in the Supreme Court. As with most of the recent Second Amendment cases being reviewed by the Supreme Court, the Ninth Circuit Court's anti-gun rights decision will be vacated, and this case will be remanded back to them, just like what happened in Morin v. Liver, which I covered in another video. The long and short of this Rhodi v. Banta case is, the days of California's ammunition purchase restrictions are numbered. And that's all I have for you in this video. If you've made it this far, you probably like this type of content. Please help us make more of these by clicking on the like, share, and subscribe buttons. And as always, thanks for watching.